Welcome. In today's topic, we're talking about the facade ship, unmasking the bespoke predator. This is Silent Screams, Loud Strength, and I'm your host, Samantha. In today's topic, we address something very profound that happens within the family courts. The architecture of the mask. So welcome to this. This is a conversation. This is not just a conversation, it is a deconstruction. Today, we dismantle the architecture of the bespoke predator, a predator who does not operate in isolation but through systems, status, and institutional alignment. This is not a marriage. This is not a relationship. This is a facade ship, a constructed reality in which one party performs legitimacy while the other is systematically erased. The bespoke predator is not defined by chaos. He is defined by curation. He is professionally embodied. He is socially validated. He is institutionally protected. His presentation is deliberate, tailored, articulate, credible. His abuse is equally deliberate, covert, sustained, evidentially diluted. This is coercive control within the meaning of Section 76 of Serious Crime Act 2015, a pattern of behavior designed to control, dominate, and destabilize. But here is the abuse. Here, the abuse does not end in the home. It is extended through legal process, through financial structuring, through reputational shielding. The partner is not a spouse. She is positioned as a supporting structure to his public identity, a prop within a system designed to preserve him. The Macpherson legacy and the blindness of the bench. In 1999, the Macpherson report defined institutional racism as the collective failure of an organization to provide an appropriate and professional service because of color, culture, or ethnic origin. That definition remains operational today. Within the family justice system, its presence is not declared, it is demonstrated. The Equality Act 2010 imposes a public sector equality duty under Section 149. Courts are required to eliminate discrimination and advance equality of opportunity. Yet, in practice, credibility is still filtered through status, presentation, and bias. Where a survivor presents with trauma, disassociation, fragmentation of memory, emotional dysregulation, these are treated as indicators of unreliability. This is a clinical and legal misapplication. Trauma responses are well documented within neurological frameworks. They do not undermine credibility, they explain survival. Failure to recognize these constitutes a failure of procedural fairness under Article 6 of the Human Rights Act 1999 and 1998, and interference within dignity and private life under Article 8. The law mandates protection. The culture of court, too, often defaults to preservation of perceived credibility. The jaw hat. Predator. Breach of professional duty. The integrity of the legal system depends on the independence and the conduct of its officers. The emergence of jaw role professionals acting as barristers, mediators, and part-time judges raises significant concerns. Where boundaries are not strictly maintained, the Bar Standards Board Handbook is unequivocal. Court Duty 1, you must observe your duty to the court, to the administration of justice. Court Duty 3, you must act with honesty and integrity. Court Duty 5, you must not behave in a way which is likely to diminish the trust and confidence which the public places on you or in the profession. Where a practitioner knowingly advances a false narrative, suppresses material facts, or relies on imbalance of power to secure an outcome, this is not advocacy. This is a dereliction of duty. Where judicial authority is perceived to be aligned, formally or informally, with one party, the requirements of impartiality is compromised. The appearance of bias alone is sufficient to undermine proceedings as established in Porter versus McGill in 2002. Justice must not only be done, it must be seen to be done. Financial attrition, Form E, and corporate veil or corporate veils. Financial disclosure in family proceedings is governed by Form E pursuant to the Family Procedure Rule 2010. The obligation is absolute. Full and frank disclosure is not optional, it is a legal requirement. Failure to disclose constitutes litigation misconduct and may amount to fraudulent misrepresentation. However, enforcement is frequently undermined by structural gaps between family law and corporate transparency. Under the Companies Act 2006, companies' accounts, directorship, and financial filings are publicly accessible through Companies House. These records often reveal operational businesses, active revenue streams, and asset control in inconsistency with the declared insolvency. The deliberate separation between personal declarations and corporate control is a recognized legal issue addressed through doctrines such as piercing the corporate veil, Prest v. Predator Resources Limited. Beneficial ownership analysis adds back and conduct arguments in financial remedy proceedings where the court fails to reconcile Form E disclosures with corporate evidence. The result is systematic. The predator retains control of assets. The survivor is left without financial resources. This is not a neutral outcome. It is a financial attrition as a form of coercive control. The use of marital funds to finance litigation against the victim further engages issues of inequality of arms, contrary to Article 6 of ECHR. The weaponization of intelligence. There exists a persistency and legal irrelevance narrative that intelligence negates victimhood. There is no statutory or evidential basis for this position. Domestic abuse, including coercive control, operates through psychological conditioning, fear, dependency, and sustained destabilization. These mechanisms are independent of education, profession, or intellectual capacity. The mischaracterization of the article survivors as calculating or strategic is a distortion of credibility assessment. It reflects bias, not evidence. The correct legal approach is to assess patterns of behavior, consistency of material facts. Collaboratively, evidence in the context of coercive control. The substitute this with subjective judgment based on perceived capability is a failure of evidential reasoning. It is incomparable with both common law principles of fairness and statutory safeguarding obligations. So, the rising voice, the legal accountability, and the reform. The framework for protection already exists. Domestic Abuse Act 2021, Serious Crime Act 2015, Section 76, Equality Act 2010, Human Rights Act 1998, Family Procedure Rules 2010. The issue is not absence of law. It is failure of application, enforcement, and integration. Where systems operate in silos, family courts, corporate regulations, criminal law, and predators exploit the gaps between these silo agencies. Where disclosure is not verified, assets are concealed. Where trauma is misunderstood, credibility is undermined. Where bias is unaddressed, injustice is repeated. This is not an individual failure. This is institutional fragmentation. Reform requires integration of corporate and family financial evidence, mandatory trauma-informed judicial training, enforced disclosures, standards with real consequences, accountability mechanisms for professionals and professional misconduct. The survivor is not the anomaly. The system response is. The facade is structural. The mask is institutional. And once identified, it is no longer defensible.